Good day everyone. Good day ma'am. I am Jennifer Cortez from 8th year Block 1. Today I explain about the Section 7 under the Rule 119 or the duties of the public attorneys where accused is imprisoned. It means if the public attorney assigned to defend a person charged with a crime knows that the latter is preventively detained either because he is charged with bailable crime but has no means to post bail, is charged with a non-bailable crime, or is serving term of imprisonment in any penal institutions. Charged with a bailable crime but can't afford bail. This means the person has been accused of a crime for which bail is allowed but they don't have the financial means to pay the bail amount set by the court. For example, if someone is charged with theft, a bailable offense, but cannot afford the bail amount, they remain in custody awaiting trial. Second is charged with a non-bailable crime. This indicates that the person is accused of a crime for which bail is not permitted under the law. For instance, serious offenses like murder or certain drug trafficking charges are typically considered non-bailable crimes. And the last is serving a term for imprisonment. This means the person is already serving a person sentence for a previous conviction or sentence. For example, let's say Maria Cruz is arrested and charged with robbery, which is bailable offense. However, Maria doesn't have the financial resources to pay the bail amount set by the court. Therefore, he remains in jail awaiting trial because he is unable to post bail despite being accused of a bailable crime. In this scenario, a public attorney would be assigned to defend Maria during his trials.
Good day, ma'am. This is the continuation of Rule 119 Trial, Section 7. A. Shall promptly undertake to obtain the presence of the prisoner for trial or cause a notice to be served on the person having custody of the prisoner, requiring such person to so advise the prisoner of his right to demand trial. This statement essentially means that the authorities will act quickly to ensure the accused person is brought to trial. If the prisoner is not present, they will inform the person holding them in the custody to notify the prisoner of their rights and demand a trial. It emphasized the importance of timely legal proceedings and ensuring that the accused is aware of their rights.
Good day. Next, we will going to discuss is letter B. Upon receipt of that notice, the custodian of the prisoner shall promptly advise the prisoner of the charge and of his right to demand trial. If at any time thereafter the prisoner informs his custodian that he demands such trial, the latter shall cause notice to the effect to send promptly to the public attorney. This section discusses what happens when a custodian or the person or authority responsible for the prisoner, such as prison warden, receives a notice of a charge against the prisoner. First, notice to prisoner. The custodian must quickly inform the prisoner about the charge against them or what violation did they commit, or this means the prisoner needs to be made aware of what they are being accused of. Second is right to demand trial. The custodian must also inform the prisoner about their right to demand trial. This is the prisoner's right to have their case heard in a court of law. Next is prisoner's decision. If the prisoner decides to demand a trial at any point after being informed of their rights, they need to inform their custodian about this decision or what the decision they made. Next is notification to public attorney. Once the custodian is informed of the prisoner's demand for a trial, they must promptly send a notice to a public attorney. The public attorney is a lawyer who represents the government in cases involving the state or other case in the Philippines. This notice is to inform the public attorney that the prisoner has requested a trial or a demand trial. And then, in essence of these provisions, ensures that the prisoners are made aware of any charges or violation or accused against them, their right to a trial, and that their request for a trial is communicated to the relevant legal authority.
This is my report. Upon receipt of such notice, the public attorney shall promptly seek to obtain the presence of the personnel for trial. To simplify this statement, upon receiving such notification, the public attorney will immediately take steps to ensure that the prisoner is brought to trial without delay. This typically involves initiating the necessary legal procedures to secure the prisoner's presence in court for their trial proceedings.
Rule 119, Section 7, Letter D. When the custodian of the prisoner receives from the public attorney a properly supported request for the availability of the prisoner for purposes of trial, the prisoner shall be made available accordingly. Certainly, this provision is part of the law, Section 12, Circular 38-98, that governs the process of the making prisoner available for trial. When a prisoner is being held by a custodian, such as jail or detention facility, it is the responsibility of custodian to ensure that the prisoner is made available for their trial. In order for the custodian to release the prisoner for trial purposes, they need to receive a request from the public attorney. Their request must be properly supported, meaning that it should include all the necessary documents and information related to the trial. Once the custodian receives this properly supported request, they are legally obliged to make the prisoner available for their trial. This means that the custodian must take the necessary steps to transport the prisoner to the court or any relevant location where the trial will take place. The purpose of this provision is to ensure that prisoner can fully participate in their own trial and have the opportunity to be present during the proceeding. By making the prisoner available for trial, it upholds their right to due process and a fair trial. Overall, this provision helped to facilitate the legal process and ensure that all parties involved have the necessary access to the prisoner for the purposes of conducting a fair and effective trial. Thank you.